Welcome to Law Module 4. I'm Dr. Ron Campbell, and it's time now to put you in the jury box. That's right. This is going to be a very active portion of the course coming up right now. But before we go any farther, I want to help you increase your knowledge of law and the amount of knowledge that you're actually retaining. And there's a secret. What I want you to do for this secret is to get a hold of the plain white index cards, and on the full clear side, take a big marking pen or the thickest thing you can and write a single word. You'll notice when you go to the textbook, Assertive Law for Busy People, that there is not a glossary. I want you to go find the definition of some various legal words. For instance, you have on the card the word summons. Well, what does the word summons mean? You should write your answer on the back where their lines are on this index card. And here's another word, the word subpoena. You'd be amazed at how many of my students confuse the term subpoena with the word summons. Now let me give you the answer right now. A summons is a request to come to court. And if you don't come to court to defend the civil lawsuit, then the plaintiff will get everything that they ask for in the complaint. So when you get a knock, knock, knock on the door and the deputy sheriff serves you with a summons, you have exactly 30 days to take action. And the action means that you have to file your pleading, a document in the courthouse. All of that is caused by a summons. Along with the summons, the judge is going to want to make sure that the defendant also received a copy of the initial lawsuit called the complaint. Now, once the lawsuit gets going, we need to get witnesses to court, and that's where this word subpoena comes into effect. Subpoenas are your court order to come to court and to do one of two things. You're either to testify or you're to bring tangible evidence. And you know what tangible evidence is. That's the smoking gun, the bloody shirt, the emails, the financial records. All of those can be subpoenaed to come to court. There's a world of difference between a summons and subpoena. So make sure you start writing down some things on the index cards. But right now, we're going to put you in the jury box. And what has happened so far is that you were told to come to court, and there may have been 30, 40, 50 people sitting in the courtroom. And then the clerk of the court called out some names at random, and you were asked to go sit in the jury box. First, the plaintiff's attorney or the district attorney, if it's a criminal case, will ask you various questions. At the end of that attorney's questioning, then several individuals will be excused. And some more people will be put into the jury box, and the questions continue again. Once those 12 people meet the satisfaction of the moving party, then the defendant and their attorney get to ask questions. And the selection of juries can take 10 minutes or can take several weeks. But it's very important that we get people in the jury box who understand their duties, their responsibilities. They have to be able to hear, they have to be able to see, they have to be able to understand. When I put people in the jury box as a trial attorney, I wanted to make sure that people had an inkling of what the case was about. So if they had any problems with that subject matter, they could tell us about their problems before I selected them as a trial attorney. But all that's coming up. We're going to take a look at people serving on the jury in either a civil lawsuit or a criminal lawsuit, and your narrator is Mr. Charles Kuralt.
Weeks now convened this evening for the regular dispatch of business. The Honorable Judge Gregory A. Weeks, President presiding. Oh, yes, yes, yes. God save the state and this honorable court. Please be seated.
Members of the jury, the attorneys at this time will have an opportunity to make opening statements if they...
Not going to be a single witness to take that stand who can testify about the events on the evening of July 2nd.
Do you solemnly swear the testimony you're about to give this court and jury shall be the truth, the whole truth, and nothing but the truth?
On the night in question, I was watching TV and I heard the accident. I looked out the window and I saw the driver.
That evening, did you have occasion to receive a report of a drunk driver?
He was unsteady on his feet and he was unable to follow directions.
You will hand the envelope containing the verdict form to the bailiff.
We, the jury, by unanimous verdict, find the defendant to be...
Welcome to jury service. Most people call it jury duty, but really it's a service to your fellow citizens, both in North Carolina and in the community in which you live. You're being asked to make decisions that affect others' civil rights or property rights. You may be asked to help determine someone's right to freedom or even to life itself. Your contribution is invaluable to the court. Jury service is at the heart of the American system of justice. The United States is one of several countries where citizens participate directly in the legal process. It's part of our democratic tradition. We have settled legal disputes by jury trials for more than 200 years, which means you're now part of a long-standing historical tradition that you can be especially proud of. As you prepare for jury service, it's important to understand how the court system is organized and what to expect as a juror. North Carolina has a unified state court system. This means the courts function the same way in all 100 counties. Whether you are serving as a juror in Halifax County or Mecklenburg or Cherokee, the way the court's structured, the personnel involved, and the judicial process are the same. This unified system is called the General Court of Justice. The General Court of Justice is made up of 3 different divisions: District Court, Superior Court, and the Appellate Division. The District Court Division and the Superior Court Division make up the trial courts. Their function is to consider evidence in cases and make judgments based on the facts presented, the appropriate laws, and on legal precedents. The District Court hears civil, juvenile, domestic, and misdemeanor criminal cases. Only civil cases are tried before a jury in District Court. Other cases are heard solely by a judge. The Superior Court has general trial jurisdiction over civil cases, misdemeanor cases appealed from District Court, and felony criminal cases. Sessions of this court are held in every county of the state at least twice a year. The Appellate Division is made up of the Supreme Court and the Court of Appeals. They are both located in Raleigh, and cases in these courts are heard by a panel of judges. These courts determine whether the law has been applied correctly in cases that have been appealed from the trial courts. And it's the Chief Justice of the Supreme Court who serves as the administrative head of the entire court system. If this is your first time serving as a juror, you may not be familiar with the jobs of the people who work in the courtroom. The judge presides over the trial and is responsible for ruling on all questions of law and court procedure. At the end of the trial, the judge will give you instructions on the law as it applies to the case you've just heard. The deputy or assistant clerk of Superior Court is responsible for administering oaths to witnesses and jurors and for keeping the court's records. The court reporter records everything that is said in the courtroom during the trial. This person provides an exact record of all proceedings. The bailiff is a deputy sheriff who enforces the court's orders and maintains security. If any emergency or any personal need arises during the trial, tell the bailiff. Seated in front of the judge's bench are the attorneys. In a civil trial, which is a dispute between 2 or more parties, there is a plaintiff and attorney at one table and a defendant and attorney at the other. The plaintiff is the person making the accusation against another party, the defendant or defendants. In criminal cases, which include both felonies and misdemeanors, the attorneys are the defense attorney and the district attorney, or DA. It is the DA's responsibility to prosecute cases on behalf of the citizens of your county. The defense attorney represents the defendant, the person who's been charged with the crime. Witnesses are the people who may be called by either side to testify under oath about some issue in a dispute. And, of course, there's you, the juror. It's your duty to decide what the facts are after hearing the evidence presented during the trial. You need no special training to be a juror, only good old-fashioned common sense. Listen carefully to the witnesses. Are they telling the truth? Are they dependable, accurate? Just use the same tests of truthfulness you use with people every day. There are, however, several legal qualifications you must meet in order to be a juror. You must be a citizen of North Carolina and a current resident of this county. You must be at least 18 years old and physically and mentally competent. You cannot have pleaded guilty or no contest to a felony charge. You cannot have been convicted of a felony. If your citizenship rights have been restored, however, you may serve as a juror. And you cannot have served as a juror any time during the last 2 years. Jury service is an important obligation of all qualified citizens of North Carolina. It's part of our state's public policy. But if you have a compelling hardship and are needed elsewhere, you may ask to be excused from jury service or have your service deferred to a more convenient time. A judge will decide whether your request is acceptable. Also, keep in mind that you cannot be fired from your job for serving as a juror. Neither can you be demoted. And while you will not be fully compensated for your time spent as a juror, you will be paid a small amount to cover incidental expenses. Your service to the court far exceeds the monetary compensation offered. And how were you chosen for jury service? At least every 2 years, an independent jury commission in your county prepares a master jury list of qualified citizens. The commission uses the list of registered voters and licensed drivers from your county as sources for the jury list. Your name was chosen at random from this master list. At this point, you are considered a potential juror, which means you may or may not end up serving on a case. The trial actually begins with the selection of the jury. The judge and attorneys will question you about your background and attitudes. They want to know if you have any prior knowledge of the case about to be tried, or if you've had an experience that might keep you from being completely fair in deciding the facts about the case. Yes, the questions may seem personal, but they're necessary to ensure that the most impartial jurors will be chosen. Each attorney is given a limited number of jurors to excuse without stating a specific reason. These are called peremptory challenges. A juror may also be challenged for cause. A challenge for cause might be used if a juror is related to one of the parties in the case, or is a close friend of one of them, or when it's believed that a person's past experience may affect someone's ability to make a fair decision. A person may not be chosen to serve on a jury for any one of many reasons. So if you're excused, you need not take it personally or feel offended by the decision. Once a jury has been seated, each attorney makes an opening statement to the jurors. Remember, these statements are not evidence. They are only presentations of what each side intends to prove to you during the trial. After opening statements, evidence will be presented. Pay close attention to what each witness says. Also, watch the witness's mannerisms and expressions. Do you believe this person is telling the truth? Do you believe this person is accurate? Your verdict may depend on whom you do or do not believe. During the course of the trial, motions and objections relating to evidence, points of law, or procedures may be made. At times, the judge may need to call the attorneys for both sides up to the bench to discuss questions about technical points of law or courtroom procedures. The judge alone must decide what is right or wrong in these instances, which is why the jury is not allowed to hear what the attorneys are discussing. In fact, the jury may be excused or a recess called while a judge makes a ruling. Such motions are common. They're there to ensure all parties get a fair trial. Also, in the interest of fairness, the judge may tell you to disregard or ignore what someone said. This is usually in response to an objection by one of the attorneys. While forgetting may be difficult, you must not consider statements the judge orders stricken or removed from the record. During your jury service, you must not talk to one another about court proceedings or about the trial. You must not talk to any of the parties involved in the trial, including witnesses and lawyers, about any aspect of the case. If anyone tries to talk to you about the case, report it to the judge immediately. Also, you may not talk to reporters about the case, or read newspapers, watch television, or listen to radio accounts of a trial until the case is over. Once a verdict is reached and you're dismissed by the judge, you are free to discuss the case with anyone, but you're under no obligation to do so. Occasionally, jurors believe they can reach a verdict better if they visit the scene of the crime. This is not allowed. The only time a juror can visit the scene of a crime or dispute is under court supervision with other members of the jury. You cannot conduct your own investigation of the case. You must consider the case as presented by those who investigated at the time the crime or dispute occurred. After all evidence has been introduced, the attorneys give final or closing arguments. These are summaries of their cases. Again, such statements are not considered evidence. After closing arguments, the judge will instruct you on the law that applies to the case. There are different degrees of proof required in civil and criminal cases. In a civil case, the burden of proof is by the greater weight of the evidence. But in a criminal case, the state must prove the defendant's guilt beyond a reasonable doubt. The judge will explain in detail what the burden of proof is in the case you've just heard. Pay close attention. You must understand and apply the law as the judge gives it to you, not as you think it is or would like for it to be. After the judge's instructions, you will be taken by the bailiff to the jury deliberation room. Your first job will be to choose a foreperson or chief juror. This person will speak for you in the courtroom and preside over discussions during your deliberations. The foreperson should make sure that the discussion is free enough for ideas to be shared, but orderly enough for each person to be heard. Give real consideration to the opinions of others, because in North Carolina, a verdict requires a unanimous vote. Everyone must agree. In determining your verdict, consider all the evidence presented, as well as opening and closing statements made by attorneys and the believability of witnesses, and then make up your own mind. When a verdict has been reached, the foreperson tells the bailiff. You will then be escorted back into the courtroom to announce your decision. Do not tell the bailiff or anyone else what the verdict is until the judge asks for it in open court. Occasionally, after the verdict has been presented, one of the parties may ask for the jury to be polled. Each juror will be asked individually if the verdict announced was his or her verdict, and if it is still his or her verdict. If you have any questions about what you've seen on this videotape, or any questions in general about your jury service, please ask the clerk of court or the judge. Your service to the court system, the state of North Carolina, and to your fellow citizens is very important. Pay attention to the facts, use common sense, and share opinions with your fellow jurors during the deliberation process. Jury service is your opportunity to be a part of the administration of justice. Your participation will help to ensure the safety of your community and the protection of our rights, our freedoms, and our property. Thank you for your time and your contribution to our judicial system.